Mbona upati pizza leo uniangalie pale? Mimi nasikuwa na jakali leo. Sijakuzoea huko. So bad. We are using
Sini amua kuzunguka, nataki saidi ile. Nishamwambia ya
the extent that it is not contemplated that the person who has been impeached would therefore be able to run or even express interest for nomination for purposes of Article 149. Let me then take it one step further to relate Article 149 and 148. In particular, let me start this conversation from one step behind. Our Constitution at Article 1, Subarticle 2 speaks to how our sovereign power is to be exercised. In particular, it says the people may exercise their sovereign power either directly or through their democratically elected representatives. Now,
Yeah, thank you, Malo. For the record, my name is Peter Onyama. I appear for the Senate, and for the completeness of the record, the following documents are the responses to the two replying affidavit filed on 21st of October 2024 in petition E015 and 5. And then we have written submissions which were filed on the date of October 2024. And the state also filed written submissions yesterday. They are all in the state. Allow me to make just some brief remarks to highlight our points in addition to what my colleagues have said. I will start first of all by stating that if you examine the provisions of Article 3 of the Constitution, 23.3, the grant of conservatory orders envisions the exercise of discretion by this court. It is the discretionary remedy. It's a remedy which is not available as a matter of right. The petitioner must lay before court sufficient material in accordance with the threshold which has been laid down to, of necessity, lead the court to grant that remedy of conservatory orders. And it is important then at this point to mention the full scope, the third test for the grant of conservatory orders, as contained in the Peter Gatirao Munya case. The third test, this test is deeply erratic. It's also elastic. The test requires the exercise of discretion. So at paragraph 6 of the Peter Gatirao case, the Supreme Court decision, you will find the following words, which are very, very important in our case. And that's the point I wanted to make in the first instance. That the grant of conservatory orders should be guided by the inherent merits of the case, bearing in mind the public interest. Public interest has been argued by my colleague, I don't need to repeat it. The constitutional values and the proportionate magnitude and priority levels attributed to the relevant causes. That is where I want to focus my submission. The provisions of Article 23 and the paragraph 86 of the Peter Gatirao Munya case are supplemented by the provisions of Rule 3.2 of the Mutunga Rules, which require you to apply the constitutional doctrine of proportionality in the grant of conservatory orders. So that, my Lord,
Threshold is not EAB, by the way. The threshold for public participation is even lower because of that decision. And when you look at that decision, which we provided to the court does what we call procedural constitutional compliance. And what is that? You looked at whether a vote happened and the threshold within the constitution have been made. No more than that. And that is supported even by the decision of the Supreme Court, which came down just a few minutes ago. And I want to read a small excerpt, Your Lordship, on that decision, which we have provided to the court.
Which one are you talking about?
I'm talking of the, it is the, Lordship, and just the citation is E031 of 2024, consolidated with E032, E033 of 2024. Came down just a few hours ago. And I will just refer the
How is it reported?
It is reported as E031. Let me just not yet reported, but it is petition number E031 of 2024, Cabinet Secretary for National Treasury versus Okia Omtata.
Petition number?
E031 of 2024, as consolidated with petition number E032, E033 of 2024, Okia Omtata, the Cabinet Secretary for National Treasury versus Okia Omtata. I argue that matter was led by Professor Jim Mungai. Mr. Ochiel, that is there, he can rebut, but he was part of those proceedings. So the threshold is even lower for public participation, number one. That is something that the court has to look at. But importantly, what did the court say about interference at paragraph 208? And I will end here, Your Lordship. Paragraph 208, the Supreme Court of the Republic it quoted the case of International Trade Administration Commission was in South Africa, and this is what it said. I'll just read a small excerpt. Where the Constitution or valid legislation has entrusted specific powers and functions to a particular branch of government, courts may not usurp that power or function by making a decision of their preference. I think that is good law. It is a direction for you. And if you look at that case, if you look at Peter Munya, if you look at the negatory aspect, and if you look at the fact that there is at what the submissions of Marjan Hussein Marjan and our submissions, you will find there is an express constitutional injunction against interference, not only for this court, even against IEBC. Because if you told me this is an election you are able to clear, then I'll tell you how am I supposed to conduct this nomination process? And what are the constitutional orders flowing from that? Your Lordship, our submissions are sufficient. I am being told to step down, but thank you so much.
Who has told you?
Oh.
Who has told you to step
No,
down?
I was being told by Professor Gili
The professors on this side, my lord.
my professor is telling me to step down, but if I can, just a second.
Okay, you can step down.
No, but Professor, but our submissions are those ones, they are on record, and even if there is a role to be played by IEBC, our position is those are administrative roles which we will still play, but, and that is provided for under Section 11 of the IEBC Act, Section 13(1) of the IEBC Act. The role that we have to do under 137 is to check the voters register, and we check voters register for even people who, for Kenyans every other day, it's a public document. There's no role for the IEBC to play, and if the court was supposed to make there was a role for us, then we say those are administrative roles, but the court should not find a role for us.
This supply authority you have quoted of E031 to E033 of 2024.
I will, it is hot off the press, I will submit it just now.
Submit to our assessors.
I will, Your Lordship. I will, thank you so much, Police.
My Lord, I want to apologize if I am here to take judicial discretion from you. It was intended to keep my promise to you that we would not do.
We now get to know that every side has a prefect. This side, the prefect is Professor Gizu.
My Lord,
Direction on whether persons who are not parties to the application, because there are only two applicants, have a right of reply, because my understanding is that the only persons with the right of reply are the parties who filed the application, not the entire coterie of this side.
Are the two things?
Why are we being preempted?
No, the two things on way forward. I think we still have to hear interested parties, or we have that. Anybody? We finished with yes. Now the right to rejoinder is only limited to the applicant and not any other person supporting the application. So it will go only to the applicant. And in this case, we have two, and we'll have how much?
You have given us 30 minutes. I am addressing the court, please. Reply to the court. You have given us 30 minutes.
My Lord, do we do 15 or 2020?
No, my Lord, there is a lot that has been canvassed. In fact, they have given us the impression that they will need less than an hour. We have obviously done 4 hours and something. There was things that
Okay, let us
we can do within 30 minutes.
Let's
or less, depending on how much is able to cover. The only issue, my Lord, that is the mischief is that since this is a court of record, we do not want to be accused there is anything that needed a response that was not responded to. Otherwise, I'm very tired. We don't want to be here forever. So we just are here to do the business and we go.
Okay, this is the way forward. We will give the respondents the time they need. 30 minutes each. Not the respondent, but the applicant. 30. Let's go.
My Lord, may I please the court? Because I'm on what issue? On the same issue. Because I've been standing and I did cut your eye. Still on the issue of the right of reply. My lords, you might remember that I am, first of all, I am one of the unrepresented petitioners in petition 11, and for the my lord, you might remember that for the last 2 weeks when this matter has been being handled, I have been insisting that we made an application for conservatory orders prior to even the applications we are discussing now, and it was in the best interest of all of us that when discussing the conservatory applications, we be treated as respondents. My lord, unfortunately, when the court gave directions, it consolidated all the petitions, but did not give directions on how our applications will be had.
Now, Mr. Bosso, just a minute. We will restrict ourselves to the applications at hand. So if yours is not among the 2 applications, then you may have to address that later. And the rejoinder should be on point of law. Rejoinder should be on point of law.
My lord, I stand guided, but I still wish to point out that there are very specific issues that I raised that were not raised by the other applicants, and which the other side has responded to, and would leave the issues unresponded to altogether.
You can pass those submissions to their counsel for the other applicants.
My lord, before counsel proceeds, I am Mwani Munga, counsel for the 43rd petitioner, Mr. Moraro Moke, and we also had an application with we believe we have a right to rejoinder, brief rejoinder, and it was one of the applications that was passed. So we also have a brief right to rejoinder. Will only take 5 minutes.
My lord, Moraro appeared in person and argued his own case.
And I am his counsel.
We
appear together with him.
Let us give directions and we will proceed with these directions which my lord that very much going to give. There must be order in every proceeding.
We'll be starting with Mr. Yes, proceed.
My lord, my name is Ochiel, and it's a great privilege and honor for me to appear before you and to make the Deputy President rejoinder. Ochiel Dudley is my name. My lord, allow me to begin with where my very good friend Mr. Samani stopped. I think he intended to cite to you paragraphs 209 and 210 of the Supreme Court decision. He stopped at 208. I believe that was a mistake. Because if you look at paragraph 209, this is what the Supreme Court
indications and directions earlier that we said 2 minutes. I wish to call upon Waidera, who was on appeal before, so that I donate my time to her in the spirit of Matthew young talent, so that she can also raise a tenor to be paid.
Yes, so Waidera, how are you? You have been granted file, so take it and make your submissions.
Thank you, my senior Mr. Nibel. My name is Wanjiku Waidera for the 9th petitioner. And taking off from where my senior Mr. Wanjiku left off, I wish to submit on the issue that the respondents raised in their responses, that is separation of powers, in which they are seeking to have their applications dismissed on account that Parliament has privilege, the respondents, that is the Senate and the National Assembly, have privileges to conduct their proceedings, and such proceedings must not be challenged in court. And I wish for this court to be guided by the decision of Justice Lenaola in the Commission for Implementation of the Constitution versus the National Assembly of Kenya and 2 others, 2013 EKIR. And I will quote part of the passage where the court said that, to my mind, the separation of powers is not an absolute To my mind, the separation of power principle contained in the Constitution is not absolute, and the courts as defenders and protectors of the Constitution have to be allowed to interfere where there is a violation or threat of violation of the Constitution. The court further went on to say that the primary duty of the court is to the Constitution and to the law, and which must apply impartially and without fear or favor or prejudice. The Constitution requires that the state to respect, protect, and promote and fulfill the Bill of Rights. My lords and my lady, what is challenged before you are the proceedings that were undertaken at the Senate, and amongst what we are challenging is the right to be heard that was denied to the first petitioner, which forms a cornerstone under Article 47 of the Constitution. And therefore, my lords and my ladies, this court stands at crossroads of history with a rare opportunity not to merely interpret the law, but to define it in a way that will echo through generations. The decisions of these proceedings have the potential to set a benchmark that will solidify principles of accountability and strengthen our democratic foundation. We therefore invite the court to allow our application and issue the conservatory orders as prayed, and in so doing, we will be cementing the constitutional principles